afternoon, everyone. My name is Kathy Purdy. I'm a marketing manager here at Schoeneck King. I'd like to welcome you to this week's update on COVID-19 webinar. Just two quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as we can throughout as time allows. Also, if you would take a moment to complete the brief survey once today's webinar has ended, we would appreciate that, as our presenters do look at your suggestions and comments for future topics. So to start today's program, I'm going to hand it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. It's good to be back with you on a mostly snowy Tuesday. We thought we'd start off today. We're going to ask Andy Bobrecht to talk a little bit about what's going on with the CDC. The CDC has come out with some pronouncements recently. I think we're probably going to see a little more activity out of that agency as we go forward. And so we're going to kick it off with Andy today, talking about what that might mean for us here in New York.
Great. Thanks a lot, Pete. Good to be with you and everyone else today. I was happy to see some more positive news here in New York in terms of the positivity rates and the trends, all of which are continuing to be favorable and hopefully hold good things for all of us in the future. As Pete mentioned, we have seen some activity on the part of the CDC. That inevitably leads to the question of, well, what does that mean for me here in New York? I think this activity is by and large derived from the changeover in administrations and in the leadership at the CDC now, with President Biden now in the White House, and of course his appointees now managing affairs at the CDC. What I'm going to talk about today is guidance in nature. These are not requirements that are being set by the CDC, but again, just guidance recommendations on their part. I think one thing to keep in mind, of course, here in New York, we are a highly regulated state. We have a very active state bureaucracy and administrative apparatus that is managing all things COVID. But of course, that's not the case everywhere across the country. And so the CDC is providing this guidance to help fill in gaps that may exist elsewhere. I guess my other big takeaway for the clients and friends of the firm who are on with us today is inevitably there will be gaps that will come up or questions that will arise in the course of your day-to-day activities. And I look to these forms of guidance as helpful fillers. Keep points to keep in mind when a question comes up. It's something that we can consult. But I wanted to focus on really three elements today. First, we saw a more definitive pronouncement of guidance from the CDC in terms of masks and the requirement, their recommendation of masks and how to be used. And they're familiar themes for us here in New York, but I think it's important to reiterate what they are, the importance of masks. I think back to one of my first presentations that I attended, and we had an epidemiologist on back when COVID was emerging. And the very first thing she emphasized with us is mask wearing. And again, that continues to be a theme. I think that the masks are not only worn, that they're worn properly. To the extent you have employees who are not wearing them properly, of course, we want to make sure we give them that advisement. We want to train and make sure that we're showing how the mask should be worn and properly worn and fitted. So I included here just some guidance in terms of what the CDC is requiring, who should have masks on, and then some of the exemptions from that. And if we move to the next slide, you'll see some other guidance that the CDC has put out that I think is just a helpful reference tool here. I think one of the things as I was looking through this, and we see a lot of different types of masks out there, buffs in particular. One thing I noticed in this guidance is that they're not recommending thin types of material, right? So if you can see light through that material, that's not a recommended type of mask from the CDC standpoint. And I think the other point that the CDC is saying, it's certainly a preventive, helps prevent the spread, helps prevent you, an individual, if you are infected, from spreading the virus, but it also can, in a marginal way, protect you as well. So I think just keep these points in mind. Again, it's something that we deal with already here in New York, but I think is worth reiterating, and this can be a helpful resource for you when you're coaching and counseling folks on your end accordingly. In addition to that, this mask issue, another area where we saw the CDC take a more defined stand, at least on a particular issue, is the area of quarantining. So we see on the next slide, CDC has actually issued guidance that says, hey, when it comes to contact tracing and quarantining, people who may have been in close contact with someone who is positive for COVID-19, right? So close contact with an infected person, normally that dictates an automatic quarantine or isolation for that individual based on that close contact. CDC has said, however, if you have somebody who has already tested positive over the past 3 months and recovered, and they're not showing symptoms, that they're not necessarily required to be quarantined. Now, quite clearly in the guidance from the CDC, they're deferring to local health officials to make that determination as to who is and who is not subject to quarantine. But I think the notion here is that if you've already been diagnosed, had positive, and you've recovered, that the need to restrict you and subject you to quarantine is not the same, because you don't pose that risk of infection to others. Again, to emphasize, this will be left to here in New York State and predominantly local health officials who will make that determination about quarantining. I took a look this morning. I haven't seen anything official from New York in writing out there on this particular issue, but we do have some anecdotal information from contact tracers here in New York who have indicated that this is being practiced as a matter when it comes to quarantining and somebody who is exposed, but who had previously tested positive and recovered. They could be subject to a different quarantining standard. Again, the document that we're going to be looking at is the actual quarantine document. It's the local health officials that are going to dictate what does or does not need to happen here when it comes to quarantining. And you'll want to, of course, take a look at that. But I guess just don't be immediately shocked if you have someone who comes forward and says, hey, yes, I was exposed to somebody who tested positive, but I'm being told I don't have to quarantine because of a prior positive test. The last issue that I want to cover, Pete, just very briefly, has to do with guidance that the CDC published about schools and school reopening. Late last week, this received quite a bit of attention in the media, and I know our partner Kate Reed is going to talk about this in the course of her presentation as well. This was really an extensive document. A lot of thought clearly went into this. There's a lot of science that backs up the principles and the points that the CDC is making here. But my takeaway for employers is, I think, again, twofold here. One, I think the points of emphasis in terms of preventative measures and being proactive to prevent the spread that apply in school districts can likewise apply by way of guidance in employers. And again, help us fill in those gaps when we may not have a clear answer on something and we're not sure how to exactly proceed. We can look to this. And again, here with the school reopening, we have, of course, a very active, again, state and local governments who are dictating and ultimately by setting terms and conditions such as how many people can congregate in an area, what percentage, certain travel restrictions, certain quarantining restrictions, right? That all kind of dictates what schools can or can't do ultimately when it comes to reopening. But here the feds have laid out a path, if you will, that schools, municipalities, local health departments can ultimately follow should they choose to help facilitate the reopening of schools. I think the principle behind this being that they're tending to see a lower infection rate on the part of young persons. They tend to see less transmission of the virus from young persons. And of course, there's the importance of the social welfare and additional benefits that school brings through live instruction. And so balancing those risks, the CDC has come out with this guidance. So here, these are just, I think, 5 of the tenets that they focused on in the prior slide, just to keep in mind, again, this multi-layered approach to preventing the spread. In here, I just thought you might be interested in this. I think, you can digest it on your own, but this is really a synopsis of what the feds have set forth in terms of how to get to that point where schools can reopen. Again, it's going to depend on what level of infection is seen in the community, right? The lower the infection, the greater flexibility the school ultimately will have by way of recommendations to reopen. And of course, the higher the transmission, the more precautions that they're going to recommend the schools take. So Pete, that's about it right now. There's been more from the CDC too. I think, as you noted, it's important to keep an eye on what's happening there for employers. I think, again, we're going to see more and more in the weeks ahead.
Okay, thank you, Andy. I agree with that. I think we're going to see a lot more out of them, and there'll be a lot more questions about how it integrates with the New York approach. Let's turn now to Mike Billick. Mike's in our Albany office, and a couple of weeks ago we had a presentation on the OSHA guidance. A couple things in the interim. We've had a lot of questions from people, so we thought it would be worthwhile to go back over what we shared with you a couple of weeks ago in a little bit of detail, but also Mike's got some reflections as this thing settles in on where we might be headed. Mike, take it away.
All right. So yeah, as Pete mentioned, Pat in the presentation 2 weeks ago talked about OSHA's guidance that came out at the end of January. And the one key thing to remember from that is that it's guidance. It's not a rule. So it, as OSHA says in the beginning of it, it doesn't create any new enforcement obligations. Having said that, of course, OSHA is not just putting this out just to be nice. They do tend to enforce what they put out, and how they do that when it comes to guidance. It's not official, but one of the things they can use it for is a general duty clause citation. And because a general duty clause citation it's very broad, and it's that obligation of employers to keep their workplace free from recognized hazards. COVID is obviously a recognized hazard, and employers have to take feasible abatement measures. And pretty much in this guidance, this is OSHA's way of saying, this is what we feel is feasible for the workplaces, that they should have one person who is in charge of COVID at the workplace, that you should take a look at possible exposures and have basically a COVID plan for the workplace, that you should look at your ventilation. Pat talked a lot about the recommended ventilation measures that OSHA had put out in the guidance. And of course, one thing that OSHA also had in the guidance is reiterating that employees are protected under OSHA, the whistleblower statute, that they are protected when they bring up safety and health issues. They cannot be retaliated against for bringing up those issues either to you or making a complaint to OSHA, and that employers should have procedures in place to make sure an employee who complains about COVID safety is not retaliated against. So, looking at this 2 weeks later, we still don't have any word of OSHA going stronger. And that is, when I say going stronger, implementing an interim final rule. That is something that is always possible for OSHA to do. There's been a lot of call from union organizations for OSHA to do that. Thus far, there isn't. It's possible that this guidance may be it, but it is possible they may implement an interim final rule. But just looking at what's been happening over the past 2 weeks, there hasn't been a significant change in the numbers of inspections or complaints since the guidance came out in late January. Granted, we only have about a week and a half of data. And in the chat, I'm going to post a link. I think I just did it. So that is OSHA's enforcement data, and it contains just a plethora of information about the number of complaints that OSHA is receiving, how many of those complaints are referred to other agencies, how many of those complaints are actually investigated, what regions those complaints are in, and everything regarding OSHA's COVID enforcement. So generally speaking, in our region, which is Region 2, it covers New York and New Jersey, OSHA is opening up and starting a new inspection for COVID about once or twice per day, depending upon what day it is. And we haven't really seen a large uptick in those types of, or in that rate over the past week and a half. But the other link I'm going to paste and post for you is OSHA's whistleblower information. And I think that, again, it's I'm not a statistician, but taking a look at the number of complaints, whistleblower complaints that OSHA is seeing, I think we're going to start getting more of them, and more of them be investigated over the next several weeks and months. Now, 2020, in terms of OSHA whistleblower complaints, was already 30% higher than 2019, because obviously the pandemic's been going on for now almost a year, and there had been a higher rate of increase of employees complaining about safety and health issues and feeling that they were somehow retaliated against, whether it was they were terminated or some other adverse action at work because they complained about safety and health issues. Right now, we're seeing anywhere on a given day between 10 to 25 new whistleblower investigation complaints being investigated nationwide. Those aren't broken down by region, so it's hard to say what's happening in region 2. Now, one aspect that we see in our practice, and as well as we've gotten some questions about this, is, well, what do we do if somebody is refusing to work? We believe that we've taken appropriate precautions, and yet this person is still refusing to work, saying it's an unsafe workplace. So OSHA does have a standard, and it's a very high standard to meet for an employee who is refusing to work because of safety and health condition. They can only do so if they meet 5 factors. The first is that they have a reasonable apprehension of death or serious injury. They refuse to work in good faith. They have no reasonable alternative besides refusing to work, that there's no other way that they can do the work in a safe way. That they had insufficient time to eliminate the condition through other enforcement channels, such as filing a complaint with OSHA or complaining to OSHA about the situation. And where possible, they sought from the company or the employer and was unable to obtain a correction of the dangerous condition. Now, when that standard was written, it was really written in terms of I would say more of a machine guarding look. If I am going to continue doing this work, I am afraid that I am going to be immediately maimed or killed. That's really the intent, and when that standard was written. It certainly applies in these types of situations, but can it really apply to a situation where an employee is complaining about OSHA or COVID, says they won't come into work, where you have taken reasonable measures? You have fewer people in the office, you've done cleaning, you have everybody wearing masks, you've got partitions up where you can, and I would say the answer is no. If you have done what you can do feasibly to make the workplace a safe place and employees refusing to work, then in that case, yes, anybody can complain about anything. An employee can file a retaliation complaint or 11C complaint with OSHA, but it's likely that would be dismissed because you're not terminating the employee for making that complaint. You're terminating the employee because they are refusing to work when you have made it a reasonably safe place for that employee to work. So answering those issues. So with that, we'll obviously keep an eye on OSHA updating its guidance and its enforcement efforts. And of course, if they do come out with an interim final rule, we'll keep you posted on that. But Pete, that's all I have.
Mike, just real quick before I let you go, on the notion of a general whistleblower complaint, we're seeing more, as you noted. The defense to a whistleblower complaint would be that the employer acted for legitimate, non-discriminatory reasons. Is that correct? And if so, then, what would you recommend in situations that are, I guess somewhat unique?
So
putting aside the safety objection, you covered that, but so now we're talking about there's friction between the employer and the employee. So the employee is going to go to OSHA and say, look, you did this to me because I raised a safety issue. And the employer is going to need to be able to demonstrate those legitimate, non-discriminatory reasons.
Absolutely. And in those types of cases, this is HR professional crowd and legal crowd we're talking to, they've heard document before. I will say that the standard when it comes to OSHA retaliation complaints is that highest but for standard. So, but for the fact they have to prove that, but for the fact they complained about safety and health, they would not have been terminated or had that other action. The main thing I would say when it comes to these types of complaints is you don't want to have that situation where nothing has changed. I actually just got a call from a client yesterday. Don't know if he's on the webinar or not, but is the situation where they somebody was had a performance issue, and this person was put on a last chance agreement, and then they go out of work, and in this case, ostensibly due to COVID, and for it on a protected leave, and now it's a situation where they want to let this person go, but nothing has changed performance-wise since the last chance agreement, and because of, except for the fact that the employee going out due to COVID. So it would be very, very difficult in that situation if you terminate the employee to say that there was some other reason other than the employee going out or complaining. So you don't want to have the only thing that's changed performance-wise to be the fact that the employee had complained about a safety or health issue.
Good point. Yep, that makes sense. Okay, great. Thank you. Thanks for the update. We wanted to spend a little bit of time, and I'm going to speak to you about this today, talking about hearings in the virtual world. I think when the pandemic started and the original lockdown started, we all sort of thought, in a couple months, we'll be back to normal. We won't be doing any hearings. We'll just wait. And then it became apparent at some point that, we couldn't wait, that it was not going to go back to normal at any time in the near future. And some things just couldn't wait. And we've moved into, I think, somewhat of a new world now of necessity, but where I think we may end up seeing virtual hearings, at least some aspects of this, be here to stay. So we thought we'd spend a few minutes talking about what they might look like. Kathy, if you could go to the next slide. Thank you. So I wanted to catalog for you some of the things, and a lot of this is not that different than what you would do in the, in the in-person world. Some of it is, and so, you got to think about how you would do that. So some of the things that are a little bit unique is, that before a hearing, you'll need to identify the hearing platform. Some arbitrators, the State Division of Human Rights, the courts, some agencies will do that for you. But in some contexts, you may be in the position where you either can weigh in on that, or you perhaps would even be the provider if we're talking about an arbitration situation or some sort of private mediation situation. So you're going to need to identify, what platform you're going to use. And then the second recommendation would be that you need to really be used to, and what I would call facile with that platform. You need to be able to use it without a lot of thought and without a lot of hiccups. And so practicing with a platform is usually recommended. A lot of us have now familiarity with our favorite platform, be it Teams or Zoom or whatever the case may be. So we may not need to practice, but thinking through it, just because you use Zoom every day for work meetings doesn't mean that your witnesses will, or that all the players in this proceeding will. And so making sure that people are able to manipulate the controls, turn their video on and off, mute, et cetera, that's important. So it's, I think, recommended that you practice with the platform. In terms of witness preparation, this is one of the things that I don't think has really changed. There is no substitute for spending time talking through the case and refreshing everyone's recollection, making sure that people understand what the hearing entails and making sure that they're prepared to testify. So the mode of witness preparation may change if you're not going to do that in person, but this is a key step, and frankly, it's not changing. Identifying exhibits, that likewise hasn't changed. But in the virtual world, oftentimes we're going to be sharing those in advance, stipulating to exhibits, potentially disagreeing to exhibits, and trying to resolve that prior to the hearing. So some of our more informal hearings, like arbitration, or hearings before the State Division of Human Rights, where there isn't pre-trial discovery, and historically there hasn't been a lot of sharing of exhibits in advance. That's now something that you have to do, and that changes things a little bit strategically. You may be in a position where you're not sure you want to use an exhibit, and so do you over disclose or under disclose? I mean, how do you handle that issue? So there are some unique things that come with getting ready for a virtual hearing in terms of the documentary evidence that you're going to want to use to support your case. I have an observation here. I think it takes longer to prepare for a virtual hearing. There's less travel involved, obviously. To the extent that the parties would need to meet with each other physically, navigate parking, or they're at different locations, things of that nature. You're going to have a lot less travel, which is a plus. But I think it takes a little bit longer to do it than it does in person. The old method of getting together in a conference room, sharing documents, having conversations, that's a pretty darn good way to do it. And it's just a little bit trickier when you do it virtually. All of those things can be replicated, but in my experience, it takes a little bit more time, even if you are pretty well experienced with it. At the hearing, just a few observations. There is the option, obviously, to share a screen, but there's also the option that you use PDF documents and or even physical copies. To the extent that you're getting the documents together in advance of the hearing, that allows people, witnesses, the judge / arbitrator, opposing counsel, opposing parties, to print those out and have them in front of them. They might also be able to look at a second screen and be testifying and be present virtually at the hearing, but have the document. I'm looking here at my second screen reflexively as I talk about it. Screen sharing has some disadvantages. It's great if you have a document that was not anticipated. It can also be very good if you want to use your cursor to point to a particular part of the document or to highlight something. But you got to be pretty facile with that, because you don't want to share the wrong documents. You don't want to have your emails popping up in the lower right-hand corner, your notifications, things of that nature. I've got a preference, at least at this point, against screen sharing due to some of those disadvantages that that PDFs or physical copies can be very, very useful. Sometimes you may need a document for cross-examination or rebuttal that you didn't anticipate in advance. So you need to think about a mechanism for sharing that, to getting that to the parties. Typically email and giving people a time to caucus and, either print it out or view it. Might be something you need to fill in to allow for there to fill in the record. Also thinking about caucus rooms. Some people don't like caucus rooms because they don't trust who's in attendance, who's there. I think it's, most of the platforms, you only see the people who are actually present. But I know some parties prefer to use a separate link or get off the, the Zoom call altogether, the video platform altogether, and use a phone conference or something to ensure that when you are on the side in a confidential caucus, you're truly speaking in confidence and no one else can hear you or record you or see you. One of the things that I think is helpful is the screen view of the witnesses, and in particular, perhaps pinning the speaker. That's a feature that's available with most of these online platforms. And if you've got the view where you've got the faces of all the participants in small little boxes, that's not quite as good as having the view of the speaker be present on the screen and with a larger image, so that facial expressions, emotion, things like that can be detected. So I think that's something that you'll want to give some attention to, and perhaps even try to ask your hearing officer or arbitrator to use that function to the extent that it's important to you in the course of the hearing. Next slide, please, Kat. Okay, so what to expect? Some special issues. Well, there's the sequestration issue. That's not that complicated. Sequestration refers to having witnesses not participate in the hearing before they're going to testify, or if there's a chance that they're going to testify on rebuttal. You know, it's fairly easy to do that by having someone in a waiting room or making sure that they're not present during the proceedings. But there is this question of whether everybody is separate, completely separate, or people are separate together, as I like to call it. That is, you know, a bunch of people are together in a single conference room, and maybe, you know, one side's in one room, one side's in another room, the hearing officer's in a third place. But you need to give some thought to what that means. To the extent that people are together, but you're not with them, the possibility for people to send signals or do other things is potentially present. Typically, a hearing officer will issue instructions or oaths, including instructions that people who are testifying not be coached by others, live, you know, in person or virtually, via text. You know, there's a rule that witnesses on the stand should not be, you know, they be conferring with people about their testimony while they're testifying. And some of these platforms can create issues with that. So you'll need to give some thought to that. You'll also need to give some thought to the question of whether or not you're going to be recording. There is a recording function on most of these platforms. There is also a recording and transcription function. I don't know that how well it works. I'm personally not really comfortable with that. I think we either would want to opt for a stenographic record, a transcript of the proceedings, or no recording at all. The sort of, you know, middle road without the hallmarks of reliability is not my personal preference. But again, on any individual case, you might come up with a different, you know, a different conclusion. Recording without authorization is potentially a problem. Of course, it's a problem in an in-person hearing too, unless cell phones are seized, as sometimes happens in a court. You know, you leave it at the, you know, you check it at the door so that no one can record surreptitiously. But you know, to less formal hearings such as an arbitration or State Division of Human Rights, it is possible that someone will set record before they go in the room and have their phone on the table or in their pocket and try to create a recording of the proceedings. That's even more of a possibility when everyone's not present and nobody can see, you know, what people are doing below the screen. So it's just something to give thought to. The simplest fix to that is to give an instruction that it should not occur, which hopefully will prevent it, but also to recognize that it's a possibility and, you know, plan your behavior, testimony, and presentations accordingly. After the hearing, are post-hearing summations more important than ever? You know, they may be. I think the jury's still out on how you know, people process information for fact finding and for decision making in hearings in the virtual world. And so I'm personally thinking that a good summation is important to make sure that everything is tied together, be that in the form of an oral summation or a post-hearing brief. We also don't know yet, I don't think, whether the time for decisions will be shortened or not. My personal opinion is likely not, because people are people and, you know, they end up taking the amount of time that they take to decide these cases. But there certainly is that prospect in the sense that exhibits are oftentimes provided in advance. Perhaps the additional preparation that I referred to will result in more seamless presentations. You certainly could envision the possibility that it would shorten the time for decisions, but that remains to be seen. Next slide, please, Kat. Okay, so just some special issues I wanted to talk about. Should you try to delay to get an in-person hearing? That is something I think we would always want to consider. And the strategic question there is, what will you be missing if you do a virtual hearing? And can you compensate for that? If the answer to that is yes, then there would certainly be no reason to try to push it off. If the answer to that is no, you cannot compensate, then you certainly have an interest in trying to get a virtual hearing or an in-person hearing rather than a virtual hearing. I will say that my experience, a lot of arbitrators seem quite enamored with the virtual hearings. And there's a possibility that even after the pandemic subsides, that people will be pushing for virtual hearings. I don't know that we want to put all our eggs in the basket of, the world's going to go back to the way it was before. I think there may be some people who try to push the virtual medium even after it is no longer necessary because the pandemic is under control. Credibility determinations. I think this is probably one of the biggest things that people are nervous about in the virtual world, that we're losing something, that people are, you're going to miss the so-called Perry Mason moment. Just two things to think about there. One is there aren't that many Perry Mason moments in most hearings. That usually credibility is determined by the weight of the evidence and answers that don't lack depth and strength and appear to be evasive, rather than someone breaking down and admitting under the pressure of cross-examination that the whole thing has been a ruse. There may be some advantages. Again, I'm thinking about this pinning the video. I've been to a lot of in-person hearings where, the fact finder is not necessarily paying close attention to the witness. They're fumbling around with their notes, or, looking at documents, or doing other sorts of things, listening with one ear. So there could be the possibility that credibility determinations with the pinned video are better in some ways. So just think about that as you are preparing. So the last question I'll leave you with is building your case. What should you or could you do differently? These are things to think about, but I want to leave you with our usual advice here, which is you need to have the baseline of what are the rules, what are the standards. We're talking about a conduct case, we're talking about a contract case, we're talking about a discrimination case. You need the baseline set of expectations to be clear. And then we need to get a good set of facts relative to those baseline expectations. That is the investigation stage. That's what you do to look into what happened, what occurred, who did what, and how that relates to your baseline standards or rules. And then finally, your response. In the case of an individual discipline case, we're talking about the level of discipline. Does the punishment fit the circumstances? Or in cases that involve contracts, discriminations, things like that, does your answer make sense? Is it a legitimate, non-discriminatory result? So that's probably in the category of the more things change, the more they stay the same. Those rules never change. Those are things that you can do now, and that will inure to your benefit if you have a virtual case. Okay, I've said a lot here. We're going to turn now to Katie Anderson, and she's going to give you the update from Albany.
All right, here we go. Thank you everyone for being with us again today. Let's start with what we've been starting with the past few times. What's happening with the case count in New York? Looking at the case numbers, we're seeing a pretty rapid drop off in the amount of cases, which is great news. We're also now starting to see deaths and hospitalizations decreasing at an increased pace, which is also very good news. But still, when you're looking at this chart, the positivity rate is it's still where it was in December. So that is, it's still caution out there. It's high caution. COVID is spreading, and it's spreading still pretty rapidly. Remember that UK variant is out there and that is much more contagious. But we do have good news with the vaccine, where 10.3% of New Yorkers have received their first dose, 4.3 have received 2 doses. I like this chart because this graph shows the new reported doses administered by day throughout the country. We can see that it is increasing. Hopefully we will get to the point where it's more than 2 million a day. We're not there yet. But at this point, based on this projection, it appears as though we're going to have about 70% immunity, 70% of people having received the vaccine by September. Great news. 90%, assuming that everybody says yes to receiving the vaccine, 90% would be achieved at this rate by Thanksgiving. Also great news. So those are the big updates with the vaccine. I wanted to also put this forward. I've received a lot of questions in the last week about what do we have to show when we are getting a vaccine? You know, what do I have to bring with me? And it depends on what category makes you eligible to receive the vaccine. Let's start with the most complicated one first, age. Age, you have to bring 2 different types of proof. You have to bring proof of residence and proof of your age. Acceptable proof of residence includes, you can either bring one of the following documents: a state or government ID, a statement from your landlord stating that you live there, a rent receipt or a lease agreement, or your mortgage. Or you bring 2 of the following: current mail, so you'd bring 2 pieces of mail, school records, or a statement from another person. So it's unclear whether you have to bring 2 of each of those or 2 different ones. But I would say safe to assume bring 2 different ones if you can't get the state or government ID or the one from the category above to show your residence. For age, it's driver's license, birth certificate, passport, all the rest of those. So you have to bring each of those types of proof. Turning then to if you are an employee receiving the vaccine, or you have your employees receiving the vaccine and you need to tell them what proof they need to bring: their ID card or a badge, a letter from the employer saying such and such works for me, or a pay stub. I also know that some people have gotten away with bringing business cards. If they are a business owner and they don't receive a pay stub, they brought a business card, said that they were the owner, they got the vaccine. For the comorbidities, we went over this last week. It's a doctor's note. It's medical information showing that you have the comorbidity, or it's a signed certification that you would go through once you're at that vaccination clinic. That's what it appears to be. Again, that signed certification one, last week I said it's up to the local government. We still haven't received any information about what it contains. That remains true. We still haven't received information about what that contains. It will really be to the local government. The safest one would be to bring a doctor's note for that. And then the final topic, and this is something that has been coming to a head since the summer, but the nursing home issue has really been dragging down the governor. The reason I bring this up is to not go through what's been happening in the news, but it's important to recognize that the increased talk about revoking the governor's emergency powers could really impact all of us in significant ways. If the legislature does revoke the governor's emergency powers wholesale and does not pass any legislation to codify the restrictions that are in place because of the executive orders, lots of guidelines that are in place now will suddenly disappear. The 50-person gathering limitation, 50% occupancy in buildings, the electronic notarizations, allowing for the use of virtual meetings for the open meeting law. All of that would disappear if the legislature does not pass something subsequently in that would codify all existing executive orders. The issue with that would be, how are we going to get it's harder to get the legislature to change things based on public health metrics. And I just told you, it looks like by September, we're going to be reaching the beginning of herd immunity in New York, 70%. If we're reaching herd immunity, how then are we going to be turning the dial, moving these restrictions? And if it's in the legislature's hands, that's going to be a lot more unwieldy to change these things rapidly, because it's a large body. There's 150 people in the Assembly and 63 people in the Senate. That's a lot of deliberation that would have to occur. That's why they gave the power to the governor to make decisions quickly. Whether or not you agree with that, that's not what I'm here to talk about. But I am here to talk about that this could have a big impact on every single one of us. Remember, the governor's emergency powers expire on April 30th. So they are expiring either way. It remains to be seen whether or not they will even renew it in the budget, or if they're just going to let his emergency powers expire on April 30th. This is obviously a rapidly developing issue. The legislature is not in session this week, so we will perhaps know a little bit more by next week after they are done meeting about it this week. With that, Pete, I'm all done.
Thank you, Katie. We're going to turn now to Kate Reed. Kate's going to give you our final update of the day, an update on what's going on with the schools. Kate?
Sure. Good afternoon, everybody. So we have a couple of significant updates. One of them is what Katie was just alluding to that I wanted to highlight, which is that a large deal of why schools, both public and private, have been pivoting a lot over the last year, and the rules seem to be constantly evolving, is because they're responding to these executive orders that have been coming out really, really quickly. So as Katie noted, the authority of the governor to continue to issue those executive orders will be in question at the conclusion of April. So it remains to be seen at that point how schools will be regulated and what will be the status of all of the pending executive orders that have been issued. So another big question that raises sort of picks up where Andy Bobrick left off regarding the CDC guidance that we received last week. So on Friday, the CDC issued its very, very detailed guidance regarding a pathway towards the reopening of schools. Much of the press coverage and politics around that guidance has been that the CDC stopped short of mandating the opening of schools, and the statements from the department have been largely consistent with that CDC is not going to mandate the reopening of schools. The guidance rather contains, as Andy said, more nuanced instructions and suggestions that base the reopening status on the level of community spread. Now, in New York State, we're at a level of community spread that, consistent with that guidance, reopening would not be possible. It's also important to note, as Andy already stated, that New York is a highly regulated area that does regulate public health and education in particular at both the state and the local level. So much of our direction in New York State regarding when schools can reopen, what they need to do to reopen, is all driven by guidance from both the State Department of Health as well as our local departments of health, who've also been delegated significant authority. So all to say, it remains to be seen to what extent that CDC guidance is going to trickle down into that state and local guidance and actually impact reopening decisions in the state of New York. A big question that has come out in recent weeks also from proponents of reopening is the issue of the 6 feet of social distancing. There was some speculation or hope that the CDC guidance would essentially do away with the 6 feet requirement and have a more flexible standard. That was not, in fact, what the guidance states. In fact, they reinforced that in high-risk areas, areas with a high rate of transmission, the 6 feet of distance really is a mandate, which is consistent with how New York State has treated that as well. New York State, going back to July of 2020, has taken the position that social distancing should be the standard, and deviations from the 6 feet should only occur if there is a legitimate educational and pedagogical reason. So if, for instance, a therapist needs to perform manipulations in occupational therapy on a child, for instance, there might be a justification for that. So all to say, I don't expect, my crystal ball, I don't expect that this CDC guidance is going to trickle down into our New York State school guidance particularly quickly, but what will happen over time remains to be seen. Another big issue that came out over the last couple of weeks was the direction from the State Department of Health that authorized high-risk athletics to move forward in schools commencing on February 1st. And what was notable about that guidance was that, as we've seen a lot in the COVID regulation era, there's a lot of passing of the hot potato, essentially. So the governor authorized the State Department of Health to authorize school districts to move forward with high-risk sports. The State Department of Health then in turn said, well, school districts can move forward with high-risk sports as long as they comply with the directives set forth by their local departments of health. The local departments of health, then feeling, I think, somewhat uncomfortable that this was all on their backs, proceeded to issue guidance in all of the local departments of health, stating that school districts still have the decision ultimately to decide whether it's safe for them to move forward with high-risk sports. Every department of health at the local level statewide has now issued guidance that is voluminous and specific. There's variations from county to county regarding what representations need to be made by school districts and what measures need to be in place before schools can move forward with high-risk sports. The authority to move forward with high-risk sports, of course, has put schools in a political conundrum. There's obviously a lot of pressure from communities to get these sports up and running again, particularly in more rural areas that don't have the high risk of transmission. At the same time, I think I'm speaking honestly to say that a lot of school leaders are feeling a lot of pressure that this guidance that they've received from the local departments of health doesn't necessarily give them the guidance and cover and detail that they need to feel safe going forward. So rock in a hard place, as I said. The school athletics guidance has raised certain issues that have come up from a legal standpoint in how schools should proceed. One of those relates to school attendance. So we've received the question from a number of school districts regarding whether students need to be in attendance in person in order to participate in athletics. And it may be something that you on the call, if you're a parent or community member in a school, you may be wondering this yourself. So back last year, the state education department issued guidance that said that schools can't condition participation in extracurriculars on students attending in person. So in other words, you can't say you must be attending school in person in order to play football. Now we're seeing kind of an inverse of that question, which is a lot of parents are now coming forward to schools saying, I don't want my kid to go to school in person. I'd like my student to actually transition to remote instruction because I want them to remain safe and reduce the risk of a potential quarantine that would then interfere with their ability to play sports. So I think we're going to see a number of those requests over the coming weeks as schools finalize their high-risk sports plans. We may see an increasing number of requests from families to say, I actually want to transition my child back to remote instruction to preserve their right to play sports. Another issue relates to spectators. The guidance from the state education department and from the New York State Department of Health now specifies that spectators at school sports must be limited to 2 spectators per child that's participating. A number of the districts that we work with in the firm would like to actually go further than that and are going further than that to ban spectators altogether at extracurricular activities. Some communities are taking that well and are appreciative of that perspective. Others are pushing back and taking the position that because the guidance doesn't expressly prohibit spectators, that spectators should be permitted. So I think there will be more questions and activity around that as well. Once again, as the governor's executive powers then come to an end at the end of April, of course, all of this, as Katie said, is going to be fair game. And the regulatory framework is going to be potentially a lot different come the 1st of May. So that's about all I have to share today, Pete.
Thank you, Kate. And thank you everyone for being with us again. Sorry for running over a little bit today. Please come back and be with us again next week. We'll be back at it again. In the interim, please stay safe and we'll talk to you soon.